Carrying on from Daf 46b of Shevuot, we're in a footnote here. Even a watchman, even the wife, just as the homeowner is deemed credible to take an oath and receive payment of his claim, so is his watchman, and even the watchman's wife allowed to take an oath that so-and-so took certain items from the homeowner's house, and such an oath causes so-and-so to be liable to reimburse the homeowner. This halacha in the context of Shevuot Daf 94. And even the wife of the watchman can take the oath. Rav Papa asks, with regard to the employer's regular hired worker or regular harvester, what does that mean? Shechiru uskito. A hired worker harvester who has been assigned responsibility for safeguarding the house cannot take an oath that so-and-so took items from the house in order to enable the homeowner to collect from him. Even if the worker or harvester took the items away from so-and-so, the court returns the items to him, said the Maggid Mishnah. Since money or property is not removed from one's possession based on an uncertain claim, and the moral left that question unresolved. And that's in the Shevuot Daf 94. What was the other footnote? Hired worker is a labourer who, though he sometimes works inside the homeowner's house, is never assigned to safeguard it. His harvester is a person who comes from time to time to work for the homeowner, who compensates him with money or food, who are not appointed to safeguard the employee's property. What is halacha? The Gemara responds to this question just stand unresolved. A teiku. Amalei imavashi. If one states a claim against another that he left his house with a silver cup, the homeowner takes an oath while holding a sacred object and takes payment of his entire claim only when the items that he claims that the defendant took are those that are suitable for him to own according to his financial status, or items that are actually deposited with him, and they are items that can be beneath one's garment. There are opinions that the items in question must be items that are usually kept in the part of the house into which the defendant entered. Some say that if the items that the homeowner claimed were stolen and do not fulfill these criteria, the defendant takes an oath of inducement and is exempted. Others say that he does not take an oath, but in order to induce him to return the items, he does in fact the items that he in fact took them. The court states that those who deny monetary claims and do not pay their debts to others are in excommunication in accordance with the opinion of Ravashi. And that's from Shevuot Daf 91, and see the comment of the Ramah. And his liable to return it was halacha. The Rav actually replied, we see if the owner of the house is an affluent person, or if he is a trustworthy person to whom people deposit their valuables, as there are people who would typically have a silver cup. If the homeowner is in these categories, he takes an oath and receives payment of his claim, but if he is not, he does not receive the benefit of taking an oath in order to prove his claim. The Mishnah teaches, how does this halacha apply to one who was injured? If witnesses testified about the injured person that he entered the domain of the defendant whole, were left injured, the injured party may take an oath and receive compensation. Rav Yehuda says that Shmuel says the sages taught that he needs to take an oath in order to receive compensation only if he was injured in a place where he's able to injure himself. If witnesses testify about an injured person that he entered into the domain of the defendant whole, were left injured, and they did not see him actually sustain the injury, and he accused the other person of injuring him, while the other person did not injure him, the injured person takes an oath and receives payment of his claim. If there is proof that the defendant injured him, e.g. he was injured in a place where he is unable to injure himself, and there was no other person present with them, he receives payment of his claim without taking an oath. Even if there was another person present with them, if the witnesses are certain that the other person did not injure him, it is as if there were no other person with them, and he receives payment of his claim without taking an oath. That's in the Rambam Sefer Nezichin, Hilchot Hovo Mazik 5:4-5, Shevuot Daf 90:16. But if he was injured in a place where he was unable to injure himself, he receives compensation without taking an oath. The Gemara challenges, unless we consider that perhaps he scraped against the wall and caused the injury himself. The Gemara explains where Rabbi Chia teaches that the Mishnah is referring to a case where, for example, he has a bite on his back or on his elbows, which must have been caused by someone else. The Gemara challenges, and perhaps a different person did it to him, and not the defendant. The Gemara explains, this is the case where there is no other person with him beside the defendant. The Mishnah teaches, how does this halacha apply to one whose opposing litigant is suspect with regard to the taking of an oath, and therefore is not permitted to take the oath? One suspected as if he has been found to take a false oath, whether it was an oath of testimony or an oath under deposit, which are prescribed by Torah law, or even an oath taken in vain. The Gemara asks, For what reason does the Mishnah emphasize even though taken in vain? The Gemara explains, the Mishnah is speaking utilizing the style of, it is not necessary. It's not necessary to state that one who is suspected of falsifying these oaths is disqualified for taking an oath, as they entail the denial of a monetary claim, i.e. due to the false oath someone incurs financial loss. It is necessary to say that even that oath, an oath taken in vain, which involves merely the reputation of one's verbal commitment, nevertheless grants one the state of a person not credible and disqualified from taking an oath. The Gemara suggests, and let the Tana also teach that falsifying an oath and an utterance, which is also an oath without monetary consequences, disqualifies one from taking oaths. The Gemara responds, when the Tana teaches which types of false oath disqualify a person, it includes only oath with regard to which one takes the oath. He is at that time taking falsely taking the oath. With regard to an oath and an utterance, such as an oath that he will eat a specific fruit that day, where it can be said that he took the oath with true intention. So what does that mean? That he took the oath with true intention. It could be that at the time that he took the oath, he intended to fulfill it, so that he took the oath truthfully. If he afterward violated the oath, he's suspect, not with regard to taking a false oath, but with regard to violating the prohibition of he should not profane his word, Numbers 33. Some hold that the Gemara's conclusion is that even one who is liable for taking an oath and an utterance about the future is suspect with regard to oaths, since he is disqualified from bearing witness, as one violates the prohibition against profaning his word. Rabbeinu Tam, see the Rambam. Accordingly, the Gemara's statement here must be understood simply as an explanation as to why the example of an oath is on an utterance is not listed in the Mishnah, and intended to eat that food, but ultimately failed to do so. The Tana does not teach as one who does not fulfill such an oath retains his credibility to take oaths, since he did not consciously lie. The Gemara raised a difficulty. It works out well to make this distinction for one who is liable for an oath on an utterance like I will eat or I will not eat, where it is possible that he was not lying when he took the oath. But with regard to oath about the past, like I ate or I did not eat, what can be said? He certainly took a false oath. The Gemara answers, teach the Mishnah, i.e. understand it to mean an oath taken in vain and an oath that is similar to it, that is clearly a false or disqualified one from further oath taking. And I'll just read that footnote. One is suspect with regard to oath if he lied in an oath of testimony, or an oath on a deposit, or an oath on an utterance, or if he took a false oath or an oath in vain, the Torah citing the Rosh. One is also suspect with regard to oath if he disregarded a communal ban, Torah citing Rashi. Some hold that the only oath about the past can cause one to be suspect, e.g. an oath that he did not eat something, which if false was false when taken, since he knows what happened in the past. When an oath about the future, such an oath that he will not eat something, does not cause him to be suspect, since even if he violated the oath afterward, he could have meant it honestly when he took it. And that's in the Rambam Sefer Mishpat, Nehechat Torah V'Nitan 2:2, Shulchan Aruch Mishpat 92:2. Thank you for listening and all the best. Bye.